All right, let's go back on the record on State versus Rosario. Mr. Rosario and his attorneys are present. State Attorney's Office is present. Mr. Whedon, did you have a chance to speak to Ms. Gutierrez?
Yes, I did.
Are you intending on calling any witnesses?
No.
All right. Mr. Rosario, you're still under oath from this morning. Recall the conversation we had this morning about you testifying?
Yes, ma'am.
Is it still your intention not to testify in this trial?
Yes, ma'am.
And you understand that you have an absolute right to testify if you choose?
Yes, ma'am.
And you understand if you choose to remain silent, that you have an absolute right to do that, and I will read a jury instruction telling the jury they can't use that against you. You understand that?
Yes, ma'am.
Do you need any more time to talk to your attorneys about whether or not you are going to testify in this case?
No, ma'am.
You've had sufficient time to talk to them?
Yes, ma'am.
And you've made this decision freely and voluntarily?
Yes, ma'am.
All right. Thank you, Mr. Rosario. All right. Defense resting?
Yes, Your Honor.
I'm going to renew your motion.
Yes.
I'll have you rest in front of the jury, but let's go ahead and take care of all of this right now.
Your Honor, Mr. Williams and I had a further discussion about the juror, and Mr. Williams actually pointed out a case of Bass versus State, in which the court, the trial court.
Can you give me the cite to that case, please?
35, 7th, 3rd, 43.
Thank you.
The first GCA case.
Go ahead. I'm listening.
The trial court in that case gave instruction, essentially it's very similar to instructions that's given at the end of the case about not deciding a case based on sympathy, bias, emotion, those kind of things. And I think at this point, I'd ask the court to give that instruction. I think the court there said you should not be influenced by feelings of anger or sorry. That whole instruction that would be tailored for the moment we just experienced in the courtroom.
Mr. Williams, what's the state's position on this?
No, I have reviewed Bass. It does indicate that the instruction was given, and then just for the record, that in that case, the court affirmed the trial judge's decision not to dismiss or failure require the juror.
Right.
But I think what Mr. Weed's referring to is instruction 3.10.
Right.
It appears to me from the opinion that they gave numbers 3 and 7.
Is the state objecting to that?
We are not.
Okay. That seems like a good compromise. I don't have a problem reading. Hold on, let me go to 310. This is 3.10, paragraph 3. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. In paragraph 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in the instructions. I'm not going to say these instructions because I haven't read the instructions yet. Is that what you're asking me to do, Mr. Whedon?
Yes, Your Honor.
State?
No, we don't have an objection. I would just ask the court to preface it the same way the court in Bass did, so that they don't feel we're scolding them for being human, if that makes sense.
Oh, I wasn't just going to start reading.
I assume, Judge, I didn't want to assume. All right, thank you.
Sure. All right, you want to go ahead and renew your motion at this time?
Yes, Your Honor.
Any other arguments that you wish to make on the second JOA motion?
Nothing further.
The state?
Same response.
Court finds that the state has presented enough evidence to meet the burden of proof at this time. And I'm going to let the case go to the jury on both counts. Same ruling, same reasons as before during the first JOA motion. All right. Let's bring the jury back in. I'll have the defense rest in front of them. It's now 10:20, so I'm going to bring them back at 1 o'clock for closings, and we're going to use the time to finish up the jury instruction state. You'll need to get all the printing done.
Yes, Your Honor.
Anything else that we need to address before I read the jury back in again?
So when you give that instruction before I press it, right there.
Yes, I'm going to bring them in. All I'm going to say to them is, I understand that the last witness's testimony, I actually like how this judge phrased it, was difficult for everyone, but you shouldn't be influenced by any feelings of prejudice, sympathy, or bias, and you need to base your verdict solely on the evidence that you heard in this case. Let's bring them back in. State recognized presence of the jury.
We do, Your Honor.
Defense.
Yes, Your Honor.
All right. Welcome back. Ladies and gentlemen, the subject matter of this case is difficult, and I understand that. And the last witness that we had was understandably difficult to listen to. I need to remind you all that this case shouldn't be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Your verdict shouldn't be influenced by feelings of bias, prejudice, or sympathy. You need to base your verdict solely on the evidence that you hear in this case and the law that will be contained in the jury instruction. At this time, the state of Florida has rested their case. Mr. Whedon?
Your Honor, the defense would also rest.
Both sides have now rested, ladies and gentlemen, which means there are no further witnesses or evidence in this case. It is 10:20. We need to get the jury instructions together, and that's going to take some time to do, just to print them all out. So we have to do 18 copies and make sure everything's in order. So rather than have you sitting around for us, we're going to release you to go to lunch. We're going to start closings at 1 o'clock. So if you all would please be back like 10 minutes before 1, we'll go to close. I will read you part of the jury instructions first, then the attorneys will do closing. I'll finish reading the jury instructions, and we'll send you out to consider your verdict. All right? Don't look at anything, don't talk to anybody, and have a great extended lunch break. If you need your jury tickets re-stamped because you want to leave, let the jury room know, and I will notify them to re-stamp your tickets. All right? Thank you.
All right, leave no pass. Here's exiting.
Any objection to the instruction read to the jury from state? Defense?
Your Honor.
All right. Jury instructions. Do you have the latest version, Mr. Williams?
In an email box.
Not yet. Hold on a
They were
second.
just sent.
Oh, it'll take it a minute. Has anybody else gotten them? Because I haven't gotten them.
I've got it.
I don't. Mr. Nunley, did you get the request from Trina for for Dr. Pritchard's address? Okay, great. I still don't have. That is odd. And my Wi-Fi's working, so. Do you have them yet, Mr. Nunley?
Nope.
You close out the inbox and move it in.
I haven't met him.
I still don't have them. You sure you sent them to me?
Yours was the first name,
Just, can you just resend them, see if they'll come? For some reason, they're just not coming through right now. I have no idea why.
The email he just sent, he was just kidding.
There it is. Thank you.
Is that the one with the attachment?
I do have an attachment.
Excellent.
And they appear to be jury instructions, so I think we're all right. All right. 3.1, 3.2, any objections?
No, Your Honor, may we remain seated?
Yes.
Thank you.
Mr. Whedon, any objections to 3.1 or 3.2?
No, Your Honor.
7.1, introduction to homicide. This case.
No objection.
I'm just going to read them all to make sure there's no problem.
I'm reading them out, sort of out loud, because that's when I discover all the problems. If you find I thought we had agreed that justifiable homicide wasn't going to be read.
We took it out of the manslaughter instruction.
Okay. Are we leaving it in the introduction to homicide?
I think it's required, so that part.
Actually, there's that case now that says that even though the standard jury instructions are the standard jury instructions, they're not really required unless they apply to the case. But I don't mind reading it. I just want to clear up for the record that we took it out of manslaughter. I would then be reading it in an introduction to homicide.
I have a problem excluding that. Yeah, correct.
That's fine, I'll read it.
Sorry.
I think he said excluding.
You have a problem excluding it? You want it in?
I do not have a problem.
Okay. So you want it out?
Yes.
Thank you.
The state will remove justifiable homicide.
Well, in that case, you're going to have to remove on this third paragraph, a killing that is excusable or was committed by the use of justifiable deadly force is lawful. So you're going to need to take out or was committed by the use of justifiable deadly force. See where I am?
I do.
Any objections from defense?
No.
It should just read, a killing that is excusable is lawful. And then in the next paragraph, you're going to need to take out or resulted from justifiable use of deadly force.
I see. Both are changed now.
All right, any other changes to 7.1?
No, you're right.
Yeah.
All right, 7.2, murder in the first degree.
No objection from the state.
Okay.
Seven point 3 felony murder. Do we need to take out first degree? No, actually it needs to stay in, never mind.
No objection from the state to 7.3.
Mr. Whedon, any objections?
Just my standing objection, Judge, to felony murder being included as a consideration for the jury.
All right.
So therefore, I object to the instruction in the whole.
Same ruling as before on the felony murder issue. 7.4, murder in the second degree.
My copy of that had the first element moved up for some reason.
Found murder in the second degree?
Yes.
Mine does not. Like I said, my spacing never looks like y'all's spacing. So.
Well, I fixed it. Did you have 3 elements for murder in the second degree? Yeah, and there should be 3.
Oh, you're right. There it is.
Yeah,
I was
I
about to
got
say
moved up.
we're missing one.
But
It's
but
different.
I have fixed it and made the first element Elena Ortega instead.
Okay. No
And
problem.
renumbered.
I'll let you fix all the spacing later. Other than that one correction, any other corrections?
No other corrections and no objections from the speaker.
Mr. Whedon? Still reading?
My computer is striking things without my participation.
It's just removing instructions?
I was trying to edit. What was the third element?
Third element is what was previously the second element. First element is when it's reenacted.
She's dead.
Yes.
We know all.
There was an unlawful killing of Elena Ortega by death. Another thing was
What was the second one?
the death was caused by a criminal act of Juan Rosario.
Somebody left the computer. Okay.
Any objections to second degree murder?
No, Your Honor.
All right, 7.7 manslaughter. Your first email just came through.
State has no objection to manslaughter.
No objection.
All right, 2.1, arson of an occupied structure.
No objection.
No objection.
I don't know if this is a function of my Word program, but paragraph, element number 2, the spacing on the second line is indented for some reason.
I fixed that.
Okay. 3.4, lesser included crimes or attempts. There's a grammatical error there. There may be evidence that he committed other acts that would constitute a lesser included crime. Did you fix that?
I think it needs to indicate crimes.
Why?
And because there are multiple lesser included crimes.
Then you need to take out a
The A.
lesser. Yeah.
Yes, Your Honor.
It just doesn't.
Well, I think it should remain crime because.
It stayed crimes. We just took out the A.
Well,
It now reads, there may be evidence that he committed other acts that would constitute lesser included crimes.
But if you only choose one lesser included
I
crime.
actually now agree with Mr. Whedon that it should be singular in both places because they can only find him guilty of one lesser included crime. So it should say, in the state's view, would constitute a lesser included crime.
I'm going to refrain from saying I told you so, but go ahead and make the change.
I don't think you did, Your Honor.
All right, other than our grammatical discussion, is there any other change that needs to be made?
No, Your Honor.
No, Your Honor.
And you're not asking, one more time, you're not asking for any other lessers other than arson of a structure or criminal mischief?
Correct.
State, you requesting any other lessers?
We are not, no, Your
And
Honor.
is anyone requesting any other lessers other than the ones that have been included, murder in the second degree, manslaughter on count 1?
No.
No, Your Honor.
Arson of a structure, 12.2.
No objection from the state.
No objection.
Criminal mischief, 12.4.
No objection.
No objection.
Three point seven, plea of not guilty, reasonable doubt and burden of proof. Let me read this one. Defendant is any issues, state?
Not quite finished, Your Honor. I'm sorry.
Okay.
No objection, Your Honor.
Defense?
No objection.
3.9, weighing the evidence.
No objection to 3.9 from the state.
All right, 3.9A, defendant not testifying.
No objection.
No objection.
3.10,
No objection from the state to 3.10.
No objection.
3.11,
No objection.
No objection.
3.12,
No objection.
No objection.
3.12A,
No objection.
No objection.
3.13,
No objection.
No objection.
all right. Let's take a look at the verdict forms. Okay. Attached, no,
I'll resend these.
no problem. I just forwarded yesterday afternoon's transcripts to you. And I have the verdict forms.
You have to see them or you have not?
I have, thank you. Mr. Whedon, Mr. Dowell, do you have them?
The verdict forms? Yes, I have it.
Do you have them, Mr. Whedon?
Yes, Your Honor.
All right, any objections or changes to the verdict to count one?
No, Your Honor.
I object, Judge. Because as I've been indicating, I think that there should be set verdict form on the issue of, well, first of all, I don't think felony murder should be included, but I object to this because it doesn't provide for, doesn't have a provision in which we can determine whether the jury convicted of premeditated murder or felony murder. Is that the stating on?
All right, same ruling. Any other objections or corrections to count one?
No.
Any objections or corrections to verdicts to count two?
No, Your Honor.
No, Your Honor.
All right. We have instructions and we have verdict forms. Anything else we need to discuss before we recess?
Mr. Whedon wanted to talk about his closing argument issue.
Oh, that's right. I'm sorry. Go ahead.
Judge, the local rules I know are just guidelines, but they do instruct attorneys to stay at the podium, not to approach witnesses or the jury without court permission. Your Honor already indicated that you would not confine attorneys to the podium, but during closing, I think I would like to ask the court to instruct the state not to approach the defense table during closing. I think that's discourteous, not to point at my client and say this man committed this crime, and that'd be discourteous. I think it'd be denigrating as well, and also create the suggestion that the state has some special knowledge, and the individual prosecutor has some special knowledge that it made that assertion and did particular crime.
Are you talking about using the exact wording, this man committed this crime? Or using the wording, the evidence proves that Mr. Rosario committed this crime?
I think it's back to another point I want to make to the judge is...
Well, wait. One thing at a time. Answer that question. Are you just objecting to them ever pointing to your client and saying anything at all about the evidence?
No, they always come from the evidence.
Okay. You're just objecting to them saying this man committed this crime.
Right. And then for special knowledge from the state attorney's part. And I'm objecting to approaching the defense table during closing.
Response from, who's responding for the state?
Are you referring to me, Mr. Lee?
Yeah, I'm referring to the fire. I don't recall.
Your Honor, the state's response is that the state feels that that's effective closing argument. The whole point of closing argument is to persuade, and the whole point is to go based on the evidence. And it is the state's theory that Mr. Rosario did commit this crime. And based on the evidence, the state should be allowed to point to Mr. Rosario and to indicate to the jurors that he is in fact the person who committed this crime.
All right, let me break that down into its sections.
Yes, ma'am.
When you're pointing at Mr. Rosario, where are you standing? Where do you intend to stand? Are you walking over to the table and pointing at him, or are you just going to gesture from some place away from defense table?
Your Honor, I can't predict the future. However, I can say based on prior occasions.
Make an effort.
Yes, ma'am. I have walked in the direction towards the table. This is not something that I actually, physically touch the table, nor do I ever, get in anybody's face or anything like that. But I have taken steps over in the direction of counsel table to illustrate a point or two.
The local rule, which again is just a suggestion, does confine the attorneys to the podium. And I've given you all some leeway on not being confined to the podium, but I would ask you not to get close to defense table. All right?
Yes, ma'am.
As to the gesturing towards Mr. Rosario and saying, he committed this crime, that's pretty standard closing. I don't know that there's any rule that prohibits that. The terminology is you have to stay within the rules. It can't be your personal opinion. It obviously has to be based on the evidence. You can't say, I think he committed the crime, or the state believes he committed the crime. None of that is permissible in closing. the state believes that the evidence proves he committed the crime, however, is permissible in closing, as long as they tie it to the evidence.
I'll be back.
Okay.
One of my primary concerns was I just don't like counsel approaching the defense table. Do I like this?
I'm
And
sure
that's
you
fine.
don't. I'm sure you don't. There's a limit to what I could, I mean, it's not considered inappropriate as long as there's some space between them and the, here in the Ninth Circuit, we try to keep, that's why we try to keep people behind the podium, but I could never stay behind a podium, so I
You don't have
let
that
lawyers.
sign, but there's that sign in a lot of courtrooms that says professionalism demands courtesy.
I have it back here.
Do you? Okay. Now,
Yes.
I think it's not courteous to come over to the table. And
I understand that,
gesture.
but they are allowed to gesture towards Mr. Rosario and point at him, so to speak. Just don't get too close to the table. All
Yes,
right?
ma'am.
What's next? That was it? Okay.
So, yeah.
All right. I would encourage you all not to constantly interrupt one another's closing. Obviously, you have a legal right to make objections, and if you have an objection to make, I'm not going to stop you from making it, but I would encourage that there not be repeated objections over the same thing that interrupt the flow of either side's closing.
I assume if we make an objection, are you going to call us to the bench, or?
I usually know what you're objecting to, so sometimes I just rule from the bench, and sometimes I'll ask you what the problem is. It depends. If I have no idea what you're objecting to, then yes, I'll call you to the bench.
Because, I mean, sometimes it's a cumulative effect that the appellate court look at, especially during closing, that certain things might be said, and if you just object once, then that doesn't necessarily preserve that issue. So,
I'm aware of the cumulative effect rule, and as I said, if you need to make a legal objection, I'm not going to stop that, because you have a legal right to do that, and you're right, there is the cumulative effect rule. I've had a trial with you, but I haven't had a trial with you all, and I don't recall you doing this in your trial, Mr. Whedon, but I have had trials with attorneys who clearly are objecting just to disrupt the flow of closing, and I object to that. But I don't recall you doing that in the trial we had. You objected very little, as I recall, during closing. But I always just put it on the record that I would appreciate it if folks would refrain from objecting just to disrupt the flow of closing, because at some point I will step in and put a stop to that.
I wouldn't want
Right.
to have a jury here, you say overruled, and you're going to say something. So,
I've never understood why lawyers want to subject themselves to that, but again, that's not my call. I'm just here to say sustained or overruled, and then there comes that point when I say that is enough, sit down.
you wouldn't say that in front of the jury, though, because
Only if I got pushed into it. If an attorney repeatedly ignores the instructions the court has given at the bench, then that attorney leaves me with no choice but to instruct them in front of a jury. But I don't think you're going to fall into that category, Mr. Whedon.
I don't think so.
This is just folks who are making objections to disrupt the other side's closing, which I do not like.
Okay.
Okay? Any other questions about closing? State's reserved 90 minutes. You've reserved an hour. That's fine.
I'll close it at 45.
It's okay. All right. I'll see everybody back.
Do we need
Try
to
to get
talk
back.
anymore?
I'm sorry?
Do you want to have any further discussion now about penalty phase, mental state evaluations, or just wait for later?
Why don't I let you concentrate on closings, and then if he's convicted of first-degree murder, we'll talk about it briefly. I'm going to have to get from the jurors a little more indication as to the dates. I know that Mr. King is giving me a date that he would prefer to not schedule this. I need to get with the jurors also, and honestly, given the amount of publicity this has received, I would prefer sooner rather than later, just because I don't want these jurors to accidentally run over. I think they're obeying the court's instructions, but the longer we wait, the more likely it is that they're going to accidentally run across something, or someone's going to say something to them. and I have alternates floating around.
And Judge, the one thing I will say is it's looking like we will be able to do sooner rather than later
Okay,
for our scheduling purposes.
okay. All right, if the jury convicts Mr. Rosario first-degree murder, we'll talk about it a little bit today, and then we'll reconvene for a case management conference for the penalty phase. I think everybody's going to be pretty tired at the end of today, or tomorrow, whenever they reach a verdict. All right, we're in recess.